Hi guys. I thought I'd caught up with all the documentation being filed in the Delphi case. But no, there's a bunch more. So we're going to talk about it. We're going to go through it all. What does it mean? Well, one thing it means is that we've got a very, very biased judge in this case. But guess what? We're still watching.
It's time for you guys to start being journalists.
Before an angry Andrew Baldwin left the courthouse, 13 News overheard him speaking to Richard Allen's wife, saying, "It ain't over. The world's watching. The world sees what's going on."
So, where to start? Well, the other day, 21st, there was a transport order entered. Talked about this yesterday. For the transport of Richard Allen to Allen Superior Court for the hearing on the 18th of March, 9 a.m. and 2 p.m. So, we've all been wondering what this 2 p.m. hearing is all about. Well, we're still wondering because if we go down to the most recent document here, the session, 3/18/24, 9 a.m. No mention of a 2 p.m. No idea. Not a clue. Okay, so there was an order issued. The court, having reviewed the state's notice and request for discovery cut-off date, filed February 14th, and the defendant's list of witnesses and exhibits for contempt hearing, filed, well, just the same day, we'll get to that, now orders counsel for the defence to provide to the state all the exhibits intended to be introduced at the hearing on March 18th, on or before March the 7th. Also, an order issued for David Hennessy's request to be able to bring his laptop to his work. No! Deny. Counsel for Defence Attorney's request to allow electronic devices at hearing, filed February 15th, reviewed and denied without hearing. Counsel may contact the court executive for information regarding his request. So you can't even bring a laptop into the hearing. Another order. The court has reviewed the accused response to state's motion to compel discovery, filed February 19th. So this is the accused response to state's motion. And the state's objection to defendant's response on discovery, filed February 21st. It is reasonable for defence counsel to provide the discovery requested, and the court therefore orders defence counsel to provide discovery to the state on or before March the 8th. As the state has advanced no legal authority to support its request to the court to force defence counsel to provide deposition exhibits in advance, the court will not compel defence counsel to provide such exhibits. So we've also got response to a petition filed. We've also got a witness list and exhibits by Richard Allen for contempt hearing. We've also got a notice filed, notice of mailing transcripts to Bradley Rosie. We've also got an objection filed, response to the defendant's motion for more time. So let's look at some actual documents. First, state's objection to defendant's response on discovery, which is this thing here. Comes now the state of Indiana by its prosecuting attorney, Solicitor Nicholas Charles McClelland, respectfully objects to any kind of continuance on discovery from the defence. The state would ask the court to deny a continuance of the February 21st, 2024 deadline. In support of this motion, the state of Indiana would show the court as follows. The state has complied with the November 1st, 2023 deadline on discovery and continues to provide discovery as it is received. The information returned by counsel to the state following their removal contained less than what had been provided. So what are they arguing here? Are they arguing that the defence had kept some discovery, not returned it? Nick is arguing that the defence stole discovery, thereby requiring a complete review before it could be forwarded to substitute counsel, so to Scremin and Labrato. That's a serious allegation there, right there. That upon reinstatement of counsel, that same information was again returned to the state, reviewed by the state, and then forwarded to present counsel. That the state believes all discovery in its possession had been provided to counsel. The information provided after reinstatement is substantially the same as the original information. However, the state continues to supplement that information with anything new, including follow-up on tips that come in through the hotline. So they're still getting tips. Jail calls from the defendant and video of the defendant at the facility where he is being housed. He's on video all the time. That to date, 26 terabytes has been provided to the defence, which, period. Why don't you just finish your sentence? That might help. That to date, defence has failed to reciprocate the discovery obligation, with the exception of 6 names provided by the defence on February 13th, without clarification as to the witness's area of expertise or what they will testify to. It seems that the defence are acting in bad faith when they, at a minimum, can't identify which field of expertise their expert witnesses practicing. Wow. That the state further believes that exhibits that the defence plan to show to witnesses in the depositions should be turned over in advance of the depositions in order to prepare for said depositions. No, they're not required to turn over any evidence for depositions. Correct me if I'm wrong. This would assist in preparation for the depositions and would save taking breaks in the depositions to examine the exhibits. This also seems in compliance with the compromise by the state to allow the defence to take multiple depositions of the same witnesses. That the state attempted to resolve this with the defence without court intervention, but like the discovery, the defence refuses to turn over any exhibits. Wherefore, now comes the state of Indiana by prosecuting attorney Nicholas C. McClelland files his objection to any kind of extension for the defence to hand over discovery. The state would ask the court to order the defence to turn over any and all discovery that they have in their possession immediately, along with any exhibits they plan to use at deposition. Just to remind you that straight away, the court, having reviewed the state's notice and request for discovery, filed February 14th, and the defendant's list of witnesses and exhibits for contempt hearing, filed February 22nd, now orders counsel for the defence to provide the state all the exhibits intended to be introduced at the hearing on March 18th, on or before March the 7th. It's reasonable for the defence counsel to provide discovery requested, and the court therefore orders defence counsel to provide discovery to the state on or before March the 8th. As the state advanced no legal authority to support the request of the court to force the defence counsel to provide deposition exhibits, the court will not compel defence counsel to provide such exhibits. Yeah, because I'm sure they don't have to legally provide exhibits for depositions. At least she's got that one right. Okay, what about the biggie though? This one's just crazy. State's response to defendant's motion to dismiss for destroying exculpatory evidence. Now comes the state of Indiana by prosecuting attorney Nicholas Slickless McClelland and respectfully objects to the defendant's motion to dismiss for destroying exculpatory evidence. So remember, this was the defence filing a motion to dismiss because law enforcement taped over or destroyed or whatever interviews by Brad Holder and Patrick Westphal on the 17th of February 2017 and February 19th, 2017, respectfully. So the same week of the murders, they interviewed two of the Odinists that the defence intends to use as their third-party guilt defence at the trial. So this is about the trial, not about the contempt hearing. Are you keeping up? I'm barely keeping up, I have to tell you. And we've not got a response from Gull on this one yet, but I bet you any money she'll side with the state, whether that's right to do so or not. So this is what happened. So this is not exculpatory, nor is it potentially useful evidence. Well, that's not for you to decide. If the defence sees evidence that these guys were the real culprits, then of course it's relevant. Of course it's useful. They are simply interviews that the defence wish to use to support a wild theory of this case. Is it wilder than your theory about the murders? Is it? What gives you the right to say that it's a wild theory? That has no evidentiary support whatsoever, in your opinion. Again, not for you to decide. However, even though the interviews were not evidence, they were not destroyed by the state purposefully or in bad faith, according to you. For those reasons, the state would ask the court to deny the motion and, in support thereof, states the following. That on August 10th, 2017, I thought it was September 2017. Okay. Carroll County Prosecutor's Office investigator Steve Mullin discovered that the DVR at the Delphi Police Department for the interview room had been recording continuously for an unknown number of days, so no one had turned it off. Like I said, when I did a live stream on this, if you just leave something running, it will record white noise. That seems to be what has happened. How can we confirm that it was August the 10th, 2017 when this was discovered? Or maybe September 2017 when this was discovered? And that it wasn't done at a much, much later date to destroy evidence. How do we know? How do we know? We can't just take your word for it, Slick Nicky. We can't. Mullin determined that the data storage on the 6 terabyte drive had been consumed, causing the equipment to record over previous recordings, resulting in lost data. So presumably, it would remove the older stuff first. So what else, apart from those 2 interviews, have been destroyed by this just leaving the thing running? All of them from February 14th onwards, or just those 2 interviews? Give me something here, Nick. Give me some proof of the investigation you've done into this. Investigator Mullin called the company who installed the DVR immediately in an attempt to recover the information. The representative advised that all recordings prior to February 20th were lost. So it is all of them, then, is it? Again, prove it. On February 17th, 2017, investigators interviewed Brad Holder at the Delphi Police Department. That recorded interview was lost due to the DVR recording over, as described in paragraph 1. The narrative summary prepared by investigators from that interview has been provided to the defence. Not the same as listening to a full interview, is it? And you know full well. February 19th, investigators interviewed Patrick Westphal at his home, and a narrative report has been provided to the defence. See previous comment. The report does not indicate that the interview was recorded. So you didn't record an interview with a suspect? Wow, that is incredibly concerning. You go and interview a suspect at his home, at his convenience, and you don't record it? I'm absolutely baffled as to how this is allowed. I mean, is it the same thing as what Dan Dullard did when he interviewed Richard Allen? It wasn't Dan Dullard, was it, by any chance? That the defence suggests that the state destroyed these recordings, which they believe to be evidence that is exculpatory in nature, further claiming that the loss of the recordings was negligent or purposeful on behalf of the state. Well, that's negligent. Not recording an interview with a suspect. That's negligent, don't you think? That the interviews of Brad Holder and Patrick Westphal are neither exculpatory nor are they potentially useful evidence. Again, in your opinion, that the state did not destroy any recordings maliciously or in bad faith. Prove it. The Due Process Clause does not impose on the state an undifferentiated and absolute duty to retain and preserve all material that might be of conceivable evidentiary significance in a particular prosecution. So you can just destroy evidence willy-nilly whenever you feel like it. Well, that's great. The state only has constitutional duty to preserve materially exculpatory evidence and evidence that is potentially useful to the defence. Yeah, well, don't you think interviews with other suspects could contain materially exculpatory evidence? Do you think? That is evidence that might be expected to play a significant role in the suspect's defence. Well, it does. These do. These do. Have you never heard of a third-party guilt defence? Wow. The mere possibility that a defence may be created in the future by a piece of destroyed evidence does not mean that there was apparent exculpatory value at the time police required the item. Well, that's why you need to save it, because you won't know that, will you? Unless you can see into the future. The fact that evidence has an outsized significance for the defence is not enough to show a deprivation of the defence's due process rights. That the defence is merely speculating that the interviews that were recorded over will aid the defence, mere speculation is not enough. But they're forced to speculate because they don't have the interviews. That's a circular argument. The loss of the recordings does not justify application of the two-part test to see if the loss warrants dismissal. Again, this is directly related to the defence's theory of third-party guilt. Directly relevant. The two-part test consists of determining what kind of evidence is at issue and then determining if the evidence was destroyed in bad faith. Step 1 is to determine what evidence is at issue. Is it evidence that is materially exculpatory or potentially useful? You think not, but the defence thinks otherwise. Evidence is materially exculpatory if it possesses an exculpatory value that was apparent before the evidence was destroyed and must be of such nature that the defence would be unable to obtain comparable evidence by other reasonably available means. Well, an interview that happened 7 years ago can't be recreated, can it? And as these are suspects in the case, you would expect that a DVR isn't left running to tape over God knows how many interviews. So presumably not just Brad Holder's. And the fact that you didn't record an interview of a suspect, how many more suspects were interviews that weren't recorded? Well, we know of one. Richard Allen. Exculpatory evidence is a very narrow class of evidence uncovered during an investigation into a crime that tends to establish a criminal defendant's innocence. When we know what it means, that means it must possess an exculpatory value that was apparent before the evidence was destroyed. We've gone through that. You're just reiterating now. That exculpatory is defined as clearing or tending to clear from alleged fault or guilt, excusing. Well, apart from bad grammar, again, we know that. We know what it means. We want to know why interviews that potentially did provide the case with exculpatory evidence were taped over and not done in the first place. The state must preserve materially exculpatory evidence, and the failure to do so deprives the defendant of due process. Again, you're repetitive, but that's the defence's argument. In contrast, evidence is merely potentially useful if no more can be said than that it could have been subjected to tests, the results of which might have exonerated the defendant. Again, by grammar, but look, those interviews might have contained information that exonerated the defendant. If the state fails to preserve potentially useful evidence, it does not constitute a denial of due process unless the defendant can show that the state acted in bad faith. Okay, we don't know that the state acted in bad faith, which is why I want to know when exactly was that DVR left running. I'm pretty sure the DVR company could provide proof of when that was. The destruction of potentially useful evidence is constitutionally unproblematic, absent a showing that the state acted in bad faith. Step 2 is if the evidence is considered potentially useful, determining if the state destroyed the evidence in bad faith. Are you just repeating yourself to make your document look longer or something? That in order to show bad faith, the defendant must show that the state failed to preserve the evidence pursuant to a conscious doing of wrong because of dishonest purpose or moral obliquity. I can't say that word. Obliquity. Listen, again, what date was that DVR recording actually recorded over? And not recording suspects. Well, you can't prove that that is in bad faith, can you? You can't prove that. But surely that is incredibly bad practice. Bad faith requires a showing beyond simple bad judgment or negligence. It exists only if the defendant can show the state's failure to preserve the evidence with the conscious doing of wrong because of dishonest purpose or moral obliquity, whatever. You're repeating yourself. The lost recording of Brad Holder was clearly not materially exculpatory. How do we know? Because it's been destroyed. Again, it's a circular argument. Even if it could be described as potentially useful, it certainly was not destroyed intentionally or in bad faith. How do we know that? Just because you say so doesn't count. That the lack of a recording for the interview with Patrick Westphal is clearly not materially exculpatory. Again, how do we know? Because we can't go back in time and listen to it, can we? Even if it could be described as potentially useful, the absence of recording was not done in bad faith on the part of law enforcement. No, but see my previous comment. Further, both Holder and Westphal are still available to be interviewed and or deposed by the defence. Great. It's a good job neither of them have died. Or else what would you expect the defence to do? Have some kind of séance to bring them forward, like in spirit? Yes, they are. Yes, they are. But interviewing them now in 2024 is not the same as interviewing them in February 2017. I know you're wet behind the ears, Nick. However, don't you realise that re-interviewing someone and looking at any discrepancies is very useful? You're just not a very good lawyer, Nick, are you? No. The interviews of Westphal and Holder are not evidence at all related to this case against Richard Allen. It's squarely evidence related to this case against Richard Allen. If it was them that did the murder or people associated with them, and they provide evidence to that end, which would then exonerate Richard Allen, surely you should be able to see that. These interviews are part of an expansive 7-year investigation following thousands of leads selected by the defence to support a wild theory of this case that lacks a sufficient evidentiary foundation. Did you not read the Franks memo? Wherefore, the State objects to the defendant's motion to dismiss for destruction of exculpatory evidence and would ask the court to deny the same. Of course it will be denied. Of course it will. Because that's what Francis Gould does. Deny, deny, deny. My word. I'm now, I think, back up to date again. Let me know what you think, and I'll see you in the next video. Bye, guys.